Hello dear students, today we'll be discussing doctrine of legitimate expectations. The doctrine of legitimate expectation is a nascent addition to the rules of natural justice. It goes beyond statutory rights by serving as another device for rendering justice. The root of the principle of legitimate expectation is the constitutional principle of rule of law, which requires regularity, predictability, and certainty in governments dealing with the public. In Halsbury's Laws of England, the doctrine of legitimate expectation has been laid down in the following words, I quote, "A person may have a legitimate expectation of being treated in a certain way by an administrative authority even though he has no legal right in private law to receive such treatment." The expectation may arise either from a representation or promise made by the authority, including an implied representation, or from consistent past practice, unquote. The doctrine of legitimate expectation is the latest recruit to a long list of concepts fashioned by the courts for review of administrative actions. No doubt, the doctrine has an important place in the review. Under the said doctrine, a person may have reasonable or legitimate expectation of being treated in a certain way by an administrative authority even though he has no right in law to receive the benefit. In such a situation, if a decision is taken by an administrative authority adversely affecting his interests, he may have justifiable grievance in the light of the fact of continuous receipt of the benefit, legitimate expectation to receive the benefit or privilege which has enjoyed all throughout. Such expectation may arise either from the express promise or from consistent practice which the applicant may reasonably expect continue. Legitimate expectation is not a legal right. It is an expectation of a benefit, relief, or remedy that may ordinarily flow from a promise or established practice. The term established practice refers to a regular, consistent, predictable, and certain conduct, process, or activity of the decision-making authority. Now, dear students, let us understand the object. Principles of natural justice will apply in cases where there is some right which is likely to be affected by an act of administration. Good administration, however, demands observance of doctrine of reasonableness in other situations also where the citizens may legitimately expect to be treated fairly. The doctrine of legitimate expectation has been developed both in the context of reasonableness and in the context of natural justice. Now, dear students, let us discuss development of doctrine of legitimate expectation. Lord Denning, in the case of Smith versus Secretary of State for Home Affairs, wherein the government had cut short the period already allowed to an alien to enter and stay in England, the court held that the person had legitimate expectation to stay in England which cannot be violated without following a procedure which is fair and reasonable. In this manner, Lord Denning used the term legitimate expectation as an alternative expression to the word right. Invoking the doctrine of legitimate expectation, the House of Lords in Council of Civil Service Union versus Minister of Civil Services held that legitimate expectation may arise from an expression or promise made by the authority or from an established past practice which cannot be violated without good reasons. In this case, the administrative authority had withdrawn a long-standing practice by a mere oral instruction. The capacity of the apex court to import legal doctrines and to plant them in a different soil and climate and to make them flourish and bear fruits is tremendous. The first reference to the doctrine is found in State of Kerala versus K.G. Madhavan Pillai. In this case, the government had issued a sanction to the respondents to open new unaided schools and to upgrade the existing ones. However, after 15 days, a direction was issued to keep the sanction in abeyance. This order was challenged on the ground of violation of the principle of natural justice. The court held that the sanction order created legitimate expectation in the respondents, which was violated by the second order without following the principles of natural justice, which is sufficient to vitiate an administrative order. Now, Article 14 as the basis of the doctrine of legitimate expectation. At times, the doctrine has been based in India on Article 14 of the Constitution. This constitutional provision imposes the duty to act fairly on all public authorities, and therefore people can have legitimate expectation that they will be treated fairly by the state. As the Supreme Court has emphasized in the case of Food Corporation of India versus Cambodian Cattle Feed Industries, that in all state actions, the state and its instrumentalities have to conform to Article 14 of the Constitution, of which non-arbitrariness is a significant phase. No public authority has an unfettered discretion. It possesses powers only to use them for public good. This imposes the duty to act fairly on all public authorities, and due observance of this obligation as a part of good administration raises a reasonable or legitimate expectation in every citizen to be treated fairly in its interaction with the state and its instrumentalities, with this element forming a necessary component of the decision-making process in all the state actions. In the case of Attorney General of Hong Kong versus Nang Yun Shu, the government announced that illegal immigrants would not be deported till their cases would be considered individually on merits. A deportation order was passed against the applicant without affording opportunity. Quashing the order, the court observed, I quote, "When a public authority has promised to follow a certain procedure, it is in the interest of good administration that it should act fairly and should implement its promise so long as implementation does not interfere with its statutory duty." Unquote. In the case of Barron versus Amalgamated Engineering Union, Lord Denning stated that if a person seeks a privilege to which he has no claim, he can be turned away without a word. He need not be heard. But if he is deprived of his livelihood, he should be afforded a hearing. Likewise, if he has some right of interest or legitimate expectation of which it would not be fair to deprive him without hearing, then he should be afforded hearing. In the case of Navjyoti Corporation, Group Housing Society versus Union of India, as per the policy of government, allotment of land to housing society was to be given on the basis of first come, first served. It was held that the societies who had applied earlier could invoke the doctrine of legitimate expectation. In the case of Supreme Court Advocates on Record Association versus Union of India, the Supreme Court held that in recommending appointment to the Supreme Court, due consideration of every legitimate expectation has to be observed by the Chief Justice of India. Just as a High Court judge at the time of his initial appointment has legitimate expectation to become Chief Justice of High Court in his turn in the ordinary course, he has the legitimate expectation to be considered for appointment to the Supreme Court in his turn according to his seniority. Now, dear students, let us discuss doctrine of legitimate expectation does not apply in the contractual field. As soon as a contract is concluded, the expectation, if any, comes to an end, and thereafter the parties are bound only by the terms of the contract. The doctrine of legitimate expectation has no application in relation to a dispute arising out of a contract, that is, pure contract. In a case where a concluded contract has been arrived at, there cannot be any legitimate expectation that he would be allowed to continue with the contract. In the case of Indian Aluminium Company Limited versus Karnataka Electricity Board, a tripartite agreement was entered into between the company, the Electricity Board and the state, fixing concessional rate for supply of electricity to the company, a manufacturer of aluminium. Later, the agreement was superseded by an act of the state legislature. The act empowered the Electricity Board to increase tariff rates notwithstanding any agreement with the consumers. The increase in electricity rates was contested by the company on the ground of breach of legitimate expectation. But the Supreme Court refused to apply the principle of legitimate expectation to the fact situation in the incident case on the ground that when relationship between the parties is contractual, there is no scope for application of legitimate expectation. The agreement was not the outcome of any unilateral promise or assurance held out by the state or the board to the company. The agreement was the result of negotiations between the parties. Therefore, the foundation for application of legitimate expectation was absent. In the case of State of Karnataka versus Uma Devi, the Supreme Court observed that when a person enters a temporary employment or gets agreement as a contractual or casual worker and the engagement is not based on a proper selection as recognized by the relevant rules or procedure, he is aware of the consequences of the appointment being temporary, casual or contractual in nature. Such a person cannot invoke the theory of legitimate expectation for being confirmed in the post when an appointment to the post could be made only by following a proper procedure for selection and in cases concerned in consultation with Public Service Commission. Therefore, the theory of legitimate expectation cannot be successfully advanced by temporary, contractual or casual employees. Now, dear students, let us discuss legitimate expectation if a vested right. Legitimate expectation or settled expectation cannot be equated with a vested right. The word vest is normally used where an immediate fixed right in present or future enjoyment in respect of a property is created. With the long usage of the said word, vest has also acquired meaning as an absolute or indefeasible right. In the case of Howrah Municipal Corporation versus Gangsrop Company, it was observed that the company have only legitimate or settled expectation to obtain the sanction. Such settled expectation, if any, did not create any vested right to obtain sanction. The protection of legitimate expectations, as pointed out in D. Smith Judicial Review, is at the root of the constitutional principle of the rule of law, which requires regularity, predictability, and certainty in the government's dealings with the public. The observation of House of Lords in Council of Civil Services Unions versus Minister for Civil Services is a locus classicus on the subject. Lord Diplock observed that for a legitimate expectation to arise, the decision of the administrative authority must affect such person either, number 1, by altering rights or obligations of that person which are enforceable by or against him in private law. Number 2, by depriving him of some benefit or advantage which either, number 1, he has in the past been permitted by the decision maker to enjoy and which he can legitimately expect to be permitted to continue to do until some rational ground for withdrawing it has been communicated to him and he has been given an opportunity to comment thereon. Or number 2, he has received assurance from the decision maker that they will not be withdrawn without first giving him an opportunity of advancing reasons for contending that they should be withdrawn. Now, let us understand the legitimate expectation and estoppel. Although there is some similarity between the two doctrines and arguments under the label of estoppel and legitimate expectation are substantially the same, both the doctrines are distinct and separate. The element of acting to applicant's detriment, which is the sine qua non for invoking estoppel, is not necessarily an ingredient of legitimate expectation. From the above discussion, it is clear that the doctrine of legitimate expectation in essence imposes a duty to act fairly. Legitimate expectation may come in various forms and owe their existence to different kinds of circumstances. It is not possible to give an exhaustive list in the context of vast and fast expansion of government activities. They shift and change so fast that the start of our list would be absolute before we reach the middle. One thing, however, is clear: A court cannot assume jurisdiction to review administrative act or decision which is unfair in the opinion of the court. If that be followed, the court would be exercising jurisdiction to do the very thing which is to be done by the repository of an administrative power, that is, choosing among the course of action upon which reasonable minds might differ. With this, I conclude today's lecture on Doctrine of Legitimate Expectations. Hope you have enjoyed the session. For now, it's time to say goodbye. Stay blessed.